Good evening and welcome once again. Once again, because it's a few months ago that I had the honor and privilege to welcome you on behalf of government to the first in our series of lectures organized in conjunction with the University of St. Martin. And would like to therefore acknowledge as well Mr. Francio Guadalupe, Dr. Guadalupe of the University of St. Martin. It's a collaboration between the Department of Communication, DCOM of Government, and the university in bringing this lecture series. It reminds me when I look around in the room that when we were in Parliament of the Netherlands Antilles several years ago, and we were talking about a law on the division of properties that specifically dealt with undivided succession property. And we had a hearing in the Cultural Center on Back Street. And you almost could have said, well, if you wanted a definition of who a local was, then look at them here. All of the people then who attended that information session were local property owners who wanted to know what effect the change of law would have on their succession property that, you know, on St. Martin goes very much undivided in many families and the consequences thereof. This series is entitled The Law Matters to You. And yes, like I've said in the first introduction that we had, when the Honorable Judge Maurice de Court gave a general overview of our legal system, we said that too often our people resort to American television for the interpretation of the law. People feel that what they see on Law and Order on American television, that is how it should be. Also because of the many immigrants that we have that come from other jurisdictions, that come from other countries, you would often hear people say, that couldn't happen in St. Kitts, or that couldn't happen in Jamaica, or that couldn't happen in Guyana. And whenever I get involved in those kind of conversations, I say, yes, I agree with you. If that's the law, it couldn't happen there. But the law here is different. Yeah, but the law's wrong. But the law is the law. And Parliament is there to listen to the cries of the people, if there is any, to make adjustments to the law, to put new laws in place. But important is, and not often enough, citizens, no matter the walk of life, wait only, most of the times, until the law matters to them, to then go find out what is the law. While we all are expected to know the law the minute the law is enacted. So to discuss in our second lecture series, we have here with us well-known notary, Mrs. Meredith Boekhoudt, who will be talking on several areas, this time on civil law. In the first series, we spoke about our justice system, and now we are going within our justice system. We are going to look at specifically the civil law, and areas that the notary will address is, for instance, the inheritance law. Again, you have misconceptions that exist based on practices in other countries, based on what we have seen on television, but we also do not know that changes were made to the civil code, and therefore things are different to how it used to be. And some people feel, my father owns a property, I am, whether I'm an outside child or not, that is my father's property, and the minute he shuts his eye, I count heads, there are 4 children, I'm one of them, so I'm going to claim 25% of it. We have seen cases where children come together and try to put a wife who is not their mother out of the house because the father is now dead and that's my inheritance. And there are misconceptions about inheritance, and I think if we would have to get into the details of it, it can keep us here probably for an entire series of lectures rather than covering it in just 1 or 2 hours. Also, the whole issue on family law, the relationship between parents and their children. Nowadays, we see things changing, that a child carries 2 names. They carry the father's name, they carry the mother's name. Before, if you were a married man, you can't acknowledge a child because that child was made outside of wedlock. And today we see married people acknowledging children or having children carry their names. All kinds of things have changed. Also, the planning of your estate, what is important, how you go about it, and the division of assets. Important things to know. As I said before, on each of one of these things, the notary can spend probably days lecturing or talking or exchanging ideas with you. Tonight we have tried to squeeze it all into 2 hours, and if I keep talking about things that I don't know enough about, it is less time that will be left for the notary to explain. I saw one of my good friends who is a known property owner walk in with his yellow pad and his pen because he plans to take notes and he plans to ask questions, and I'm sure that we won't get to all of the questions and all of the answers. But I welcome you tonight, and I'm happy to see that we have a full crowd, a full house actually, and that already there are 1 or 2 who can't find somewhere to sit. There is 1 or 2 empty seats left close up front, just 1 or 2, there are no more. Thank you and enjoy the series.
I was asked to just say a few words to you this evening, and I would actually like to start by reminding you actually why the law should matter to you today, or tonight actually. And it has to do with something that we often forget. And that has to do with the law is there because we actually lack love, or because love is impossible. It's something that we hardly ever speak about in relation to the law, the question of love. But when you're talking about families, because in our feel-good moods, we like to think that families are places where there's warmth and affection and everyone loves one another. But generally, we know that that is not the case. And because there's an impossibility of love in family life, it's never completely possible. That's why people have to pursue justice. And the only way you can pursue justice is through the laws of the land. So tonight, the law matters to you so that you can try to achieve justice, to understand how you can get what is due to you. This is why the law matters to you tonight. Thank you.
The Law Matters to You keynote speaker for tonight is a civil law notary on St. Martin since 2006. Before becoming a civil law notary, she worked as a candidate notary in St. Martin, and before that, in the Netherlands. In this capacity, she assisted many persons with drafting and execution of their last will and testament, and in general, any matters related to estate planning. She holds a master's degree in notarial law from Leiden University in the Netherlands. She additionally obtained her certificate in professional education that's provided by the Stichting Beroeps op Leiden Notariaat in the Netherlands. I'm working on my Dutch this year. And has followed several courses on topic of family law with emphasis on inheritance law In fact, she has recently attended a 4-day course on the new inheritance law given by Professor Dr. Gregor van der Burg. She believes that providing information to the public by means of presentations on the topic of inheritance and family law in general is very important, and she has therefore given different presentations over the years upon request from various organizations. The Law Matters to You lecture series is honored to have her address you tonight on topics of, as the Prime Minister has already hinted to, which is wills, estate planning, and family law in general. Distinguished guests, ladies and gentlemen, please welcome our keynote speaker for this evening, Notary Meredith Boekhoudt.
I would like to start by thanking Mr. Richardson, Mr. Guadeloupe, for inviting me tonight, for the opportunity to try to bring over some of the knowledge I carry. And I have to admit that we're going to need a couple of days to discuss several of the aspects that I was asked to speak about. I'm not going to keep you here for a couple of days. I have some time today, so I'll try my best. I was also given this magic machine that will help me with the presentation. Thank you very much. So, ladies and gentlemen, I'm going to try to tell you a bit about inheritance, estate planning, and division of assets. And when it comes to, and we'll start with that point, I would like to give you a short introduction on the matter of inheritance law. The Civil Code consists of 8 books, counting book 7, 9, you would say, and the matter of inheritance is arranged in book 4. So yeah, that's already one step further. What does inheritance law regulate? It obviously regulates the matter of what happens to the assets of the deceased. Somebody passed away, what's going to happen? To whom is it going to pass over? When we talk about estate, and I have the same thing, I must admit, in situations of divorce, we like to talk about assets, but we also have to talk about debts. It all comes together, and it's the balance that counts, and hopefully it's a positive balance. Sometimes it's a negative balance, and I'll also discuss that a little bit more further down. Inheritance law, and it's with every law that you deal with, it's all interconnected. It's not just inheritance law. Whenever you're dealing with an estate, there are other matters that are related, such as as I mentioned on the sheet, is the Central Testament Registry, regulations. Somebody makes a will. How do we know that a person drafted the will, executed the will? Now, we have an ordinance that tells us that that fact has to be registered somewhere. Not the contents, I want to underscore that, not the contents of the will is being registered, but the fact that on a certain day, before a certain notary, a certain person executed a will. And that's very practical. St. Martin is quite international when it comes to our practice. It's not just, obviously, only persons that born, lived, and pass away on St. Martin. We have a lot of times we deal with deceased persons from the United States of America, for instance, or the French side, where other laws apply. Now, in the United States of America, for instance, you don't have a Central Testament Registry. So how do we know which will, if the person made several, which will was the last one? How do we know that? And that's definitely a plus in our legal system, I would say. Another aspect to inheritance is marriage. The deceased, was the deceased married or not? How was the deceased married, with or without prenuptial agreement? If there was a prenuptial agreement, what was the contents of that prenuptial agreement? Succession, tax is also something, but we don't like to talk about taxes, so we skip that quickly. Now, a little bit about estate planning. Estate planning originally started from the financial planning aspects of the wealthy. We have all these houses, we have all this money, we have all this stock. What do we do with it? We want it to go to the children, but we don't want to pay too much tax. The tax keeps coming back. So that's where estate planning came about. You would go to your advisor. How do we transfer, when do we transfer certain assets to the next generation? So originally, you would say the fiscal attractiveness of the estate planning was a major factor. I think also what has grown over the years is what I described as asset transfer. Is more the matter of control. I would like, during my lifetime, for instance, for certain assets to go to certain children or grandchildren. Or estate planning is not per se during lifetime. It can also be in situation of death. So in the scope of estate planning, you take a look at your wills. What do I need to regulate in my will? The tools that therefore are available for estate planning are, again, the marital law. Your clients may come at the office, they have certain wishes. We might not be able to help them based on the way in which they are married. The community of assets, no community of assets, just to give you an example. So that may be part of the advice. You need to do something about your marriage contract. The inheritance law, obviously. When are we going to do this? At the moment you pass away, okay, then you need to regulate it. And donation law, that's if you wish to transfer properties as a gift to the next generation. And then again, several tax laws, succession, income, transfer tax, that all comes into play. Then the matter of division of assets. In order to talk about division of assets, obviously there must be a situation that there's more than one owner of a property. And that can be because me and my sister buy a property together, and at one point we say, well, you know what, I don't want it anymore, or you don't want it anymore. We can discuss how we're going to divide it. Of course, situation of divorce, very common moment where people have to sit down and discuss how we're going to divide our assets and liabilities. And the main topic of the evening, which is death, that, we have a person pass away, the person leaves behind more than one heir, and what are we going to do? For the division of assets is important. As I reiterate again, we talk about assets, but let's not forget the liabilities. You have to take those into consideration as well. Did the deceased have a mortgage loan? Did the deceased have credit cards debt? Did the deceased maybe have some outstanding income tax payments? All those type of things. You need to take them into consideration as well when you're talking about, hey, you know, Papa passed away. What are we going to do with his estate? Inventory, therefore, is very important. That can take time sometimes. It's not like a person passed away today and within a week you have a complete inventory. No, and especially a lot of people may have a home in Aruba, maybe some money in a bank account in Anguilla, property on St. Martin, debts on St. Martin. So it can take a while. For division of assets, it's very important that all parties participate. You cannot have a division agreement if only a few or not even a majority of the heirs, and a better term would be partakers. The law talks about deelgenoten, partakers, if they are part of the agreement. Everybody has to agree. So it's not a majority vote situation. So that's another important aspect of division of assets. You need to reach an agreement. You need to talk to everybody. When it comes to division of assets, there's also option of partial division or complete division. Obviously, at least you would like to reach full, complete division as soon as possible, but that's not always a possibility. There are some emotions, lack of cooperation. Sometimes we reach further, faster, if you take it step by step. And that's what we mean with partial division and partition. So we're going to only talk about certain assets. We're going to leave the rest because that's unclear, or the sisters are fighting about the stocks, for instance. And then the last part of a division agreement is, of course, okay, the allotment, who's getting what, who's paying what, and how do you transfer it. And for transfer, and that's another different course again, a lecture on the matter of transfer of assets. What type of asset is it? Are we talking bank accounts? Are we talking movables? Are we talking immovables? So I'm going back to the inheritance law. Question number 1, what is there to inherit? And that's what I meant with, it could be a positive balance, it could be a negative balance. And this part is very important because let's use the example of a parent. If a parent passes away and you are potentially an heir in the estate, you have to watch out before you accept the estate. In accordance with the law, there are 3 options. You can accept the estate completely, you can accept it beneficiary, or you can say, thank you very much, I'm not interested, in a different legal manner, but that's what it boils down to. If you accept it completely, you become also liable personally from your own pocket for the debts of the estate. So if the estate is negative, yes, you'll sell whatever you find in the estate, but the taxman might still say, but wait a second, there's still $10,000 outstanding. Then the heirs have to dig in their own pocket and pay that $10,000. You have to. You have really replaced the deceased completely in all rights and obligations. If you refuse to accept the estate, the procedure is you have to go to court and you have to declare not to accept the estate. There are some consequences. I'll get back to that point as well later. But you have nothing, you personally have nothing to do with the assets and nothing to do with liabilities from that moment on. If you accept it beneficiary, then you are only responsible for those debts that can be covered by the assets in that same estate. So you can sell everything, you pay off as much as possible, that same $10,000 that may be still balancing over, you don't have to pay it from your own pocket. Now, you might think, oh, but then let's accept every estate beneficiary. It's not that easy. Good evening. The law is a bit complicated in the matter of beneficiary acceptance. You have to make your inventory lists, depending whether there is a dispute, you might end up in court because you need approval, go through an approval procedures, etc., etc. So, and we tend to compare it a little bit, with the permission of the court, compare it a little bit with the bankruptcy situation, where it becomes a bit more more paperwork that needs to be dealt with. So it's not something we, per definition, advise. If you doubt, I don't know, this person may have left some debts more than their assets, that we would advise you, yes, I think it's best to accept it beneficiary. In the event, another example, father passed away, it's known that father left more debts behind than assets. Would we recommend, the children have an option, they can say, well, no, we don't want to deal with his estate, I don't want it. We would still usually advise the children to accept it, but beneficiary. Why? Because if one group of heirs doesn't accept the estate, it doesn't stop there. You have to go look in the next group of heirs. So that means that suddenly uncles, brothers of the deceased, sisters of the deceased, potentially nephews and nieces, suddenly are burdened with the question, are you accepting this estate? So you're just pushing the problem away and not cleaning it up. And we say, well, clean it up. That's the advice. So, when it comes to accepting an estate, it's very important. It's just your conduct. It doesn't have to be in writing. Acceptance of estate is not something that the law says you must have signed a declaration of acceptance. No, the conduct. If I present myself as an heir, my conduct can be concluded. I'm deemed myself an heir. Then in court, the judge will say, sorry, you accepted the estate. So, questions, who inherits the estate of deceased, who represents the estate, what to do with the estate, we will be discussing a little bit further down the slides. So I'm going to the next one, with or without a will. So, John passes away. Question number one that we will have is, did John make a will? And that will be part of the research when you're doing succession work. The law says if the person didn't execute a will, then in Book 4 we can find the rules and regulations that tell us, okay, these persons will be the heirs. If you say, well, that's not what I want, you have to get advice. Say, well, that's not what I want. I don't want this person or these persons to inherit from me. Then you must make a will. So what we call an estate without a will, we call that ab intestate. Ex testamento is with a will.